to you all, and a big malo lele from the Kingdom of Tonga. Thank you for all taking the time out of your busy schedules to join us in this important webinar, which is presented by the Pacific Islands Law Officers Network Cybercrime Working Group and the Council of Europe. As many of you will know, my name is Linda Folaumoetu'i, the Attorney General of the Kingdom of Tonga, and am currently holding the chair of PILON's Cybercrime Working Group. I'm pleased to chair this webinar on the topic, Cybercrime Legislation in the Pacific, sharing perspectives on recent progress. Today's webinar will focus on the experiences of Pacific Island countries such as Kiribati and Tonga in developing their laws to address emerging cybercrime threats within the emerging cybercrime threats in line with the Council of Europe's Convention on Cybercrime, the Budapest Convention. The 2018 Boy Declaration recognized that combating cybercrime and cybersecurity are key regional priorities for the Pacific. Further, our Blue Pacific geography is unique, but the internet is making us more globally connected than ever before. This brings both new opportunities and new threats for our communities. Reflecting international standards, such as the Council of Europe's Budapest Convention on Cybercrime, in our legislative frameworks is one way we can build and become part of a global effort to effectively combat these threats. Our presenters will share how their countries approach the practical challenges which arise during the process of aligning legislation with international standards. We are very fortunate to have three very experienced presenters here with us today to share their expertise and experience on these issues with us today. Our first presenter is Mrs. Terianna Kourabi, an information security analyst. Hello, Terianna, from the Digital Transformation Office in the Kiribati Ministry of Information, Communications and Transport. As some of you may know, Kiribati passed its Cybercrime Act in 2021, and Terianna's team was instrumental in this process. Today, Terianna's presentation will focus on Kiribati's experience of drafting cybercrime legislation, adjustments that were made to reflect international standards within Kiribati's domestic framework, and the next steps for implementation of the Act. Our second presenter is Mrs. Tupou Kafa Vainikolo, Crown Prosecutor in the Criminal Division of the Attorney General's Office in Tonga. Tupou will present Tonga's experience of implementing the Budapest Convention under the current domestic framework, the capacity building programs which have assisted with this process, and outline the next steps for Tonga's legislative framework. After Terianna and Tupou's presentations, we will pause to see the progress of our live scribe, Ms. Jessamy Gee. Jessamy will be producing a graphic representation of each of our speakers sharing with us today. We will also hear from Ms. Catalina Stroe, the Program Manager for the Glacis Program. Hello, Catalina. And Catalina will present on the impacts and benefits of acceding to the Budapest Convention, the accession process, and further types of assistance the Council of Europe can extend to interested countries. I'm very much looking forward to these presentations and hope you are all too participants. Before we begin, let me first ask Catalina for her opening remarks on behalf of the Council of Europe. Catalina, thank you.
Thank you very much, AG Linda. Always a pleasure to be working with you, and nice seeing you again. And thank you very much for the kind introduction that you already made for me. Let me just first express our warm gratitude on behalf of the Council of Europe to all PILON members to this webinar, and also our gratitude to the PILON Secretariat for our long-standing relationship and kind support they extended to for this event to happen. Council of Europe has been partnering with PILON in raising awareness on the cyber threats and finding mutual approaches to augment the adoption of national cybercrime legal frameworks aligned to international standards in the Pacific region. As Linda already mentioned, this webinar is co-organized by PILON Cybercrime Working Group and Council of Europe, and hopefully the three of us will be able to address some key points of the need of harmonized legal framework on cybercrime and electronic evidence in line with international standards, as AG Linda already mentioned Budapest Convention as a crucial milestone in equipping our criminal justice authorities in the region in addressing the cybercrime issues. Of course, it will also offer the possibility for Pacific countries to share approaches of their country has taken already. AG Linda mentioned that Terianna and Tupou, nice to meet you again. Tupou, very nice to meet you, Terianna. We'll be discussing the steps that have been taken by their countries to identify solutions to further strengthen the criminal justice response in their own countries, and hopefully to give some impulse also to other countries in the region. I will just stop here because I will have also a presentation on my side. Thank you very much, AG Linda, back to you.
Thank you very much, Catalina, and always a joy to see you also. We will now start with our presentations. And at this point in time, I will invite Terianna Kourabi from the government of Kiribati to kindly share her presentation with us. Thank you, Terianna.
Thank you. Mary, my name is Terianna, and I'm very happy to be part of this channel to share about Kiribati's journey in establishing our Cybercrime Act with you all. Next slide, please. So in this session, I will first introduce my workplace and acknowledge those who have made this legislation possible. I know how hard they have worked for this. Then on our national policy, the government priority in relation to cybercrime, the Act was a process of drafting success and challenges, including lessons that we learned throughout the process. And lastly, I will talk about way forwards given to the passing and enactment in this legislation. Next slide, please. So as a way of introduction, I'm an information security analyst at the Ministry of Information, Communication and Transport, Digital Transformation Office under the Cybersecurity and Emergency Response Team, the SAFE unit. And also our team have been leading the development and establishment of the Cybercrime Act. We also would like to commend and introduce other various stakeholders who have made this Cybercrime Act achievable, including the Office of the Attorney General, who have been instrumental in making this act possible. And the third, which I am part of, is responsible for cybersecurity development, policy, and planning and incident response. So we have a broad role in cybersecurity, and there's from time to time play a key role in being an advisory body for the government of Kiribati, and our involvement in establishing this cybercrime law. Not forgetting the law enforcement unit, the Kiribati Police Service, for their crucial contribution as well to this legislation as well. Last but not least is our international partners, especially the Australian Attorney General Department, AGD, and the Council of Europe as being key partners in developing this legislation. Okay, well, and the Kiribati National ICT Policy was approved and published in 2019, outlining several ICT developmental goals Kiribati will embark for the next 5 to 6 years. And the policy comprises of various ambitions the government will prioritize for key developments in ICT on the national level. And one of these goals is shown in this slide here. A need to establish a comprehensive cyber law or cybercrime law to ensure our people are well protected from cyber criminals. This is perhaps one of the core foundations as we embark on establishing this cybercrime law. And this was established in 2019 as the Kiribati government ICT policy. And the goals and activities outlined in the policy are given greater priority in funds and in parliament. So this is perhaps also a good recommendation for those seeking to establish the cybercrime law, is to ensure that the establishment is enshrined in the government policy so that you can have both technical and political supports needed to pursue the path of the establishment of the cybercrime law. So perhaps one thing that is also very important after having a policy provision for establishing the cybercrime law is to ensure that this will be a priority within the government. And in our case, we try to ensure that activities related to establishing the cybercrime law is given resources and the time to ensure that it will progress. The appropriate planning was a key factor as well when we were trying to ensure that legislation can be established in a given time frame. And perhaps to put it in steps, it will be crucial to identify key stakeholders at the beginning of the planning phase. And in our case, we work extensively with our Attorney General Office colleagues, as they are the key people to kickstart the processes. So we held a number of consultation with the Attorney General and the Kiribati Police Service, just to ensure that we have their perspective from the prosecution point of view to the law enforcement on expectations and issues currently faced by their respective agencies in relation to cybercrime. But prior to this, we must seek the Cabinet's approval on actually starting the drafting processes. So we are also given guaranteed that this law will be given a time to be tabled at Parliament. And this was done and approved by Cabinet, and henceforth our work commenced. And after extensive consultation, we are starting to draft clear expectations and goals the legislation should have. And lastly, we set a time frame to ensure that we have progress from time to time to ensure that we have a timeline to catch up to. And I think this is crucial so that all key stakeholders also have a clear understanding on the time. And since this has been given priority by Cabinet, all government stakeholders will put time and resources toward progressing this activity. So those three key steps are crucial and only achievable as government give priority to this activity. So prioritizing and having all key stakeholders on board is very important to ensure that the process progress over time. Okay. Also, as part of our ongoing engagement with the region on cybersecurity and cybercrime, we have an exposure to the Budapest Convention at one event like this. Well, it's not virtual, but in physical meeting, where we were made aware of the Budapest Convention on cybercrime. And we learned that Tonga at that time is in the process of accession to the convention. And through this exposure, we learned quite a lot on benefits and advantages of the convention. And thus, this led to our initial discussion with the Australian Attorney General's representative at the events on ways we can collaborate and partner with them as we plan to embark on establishing our legislation. I will leave the Budapest Convention discussion to the Council. But this was a decision we made at the time to align our laws with the convention, given the many advantages we can draw if we were to become part of it. And thankfully, the Australian, the Attorney General's Department managed to link us to the Council of Europe. And that is where the actual process began in the drafting of our cybercrime law. The drafting was led from our side by the Office of the Attorney General in Kiribati through its drafting unit. And the Council availed experts for a gap analysis assessments on the legislational landscape. And after the report came back, we kick off on actual writing on provisions in the legislation. So this was all done virtually. The HED and the Council of Europe has been crucial partners to ensure all provisions in the legislation align with the convention, and also ensure that all provisions in the convention are reflected in the legislation. The key stakeholders came together and discussed what other additional provisions Kiribati wants to see in the cybercrime law to reflect the need by people and also address pressing cyber-related crimes in Kiribati. And this is quite crucial as we have to ensure that the law reflects our context and also address persisting issues around this area. So once this was done, we go through several iteration of reviews by the Council of Europe experts and the Attorney General Department. The Attorney General Department expert refining the provisions to ensure it is as accurate and clear as possible. So this is crucial as we learn quite a lot as we refine the provisions and see more provisions, including wording that may need to be reviewed to ensure that it is clear and does not present ambiguity to the law. So as such, we would like to thank again the Council of Europe and the Australian Attorney General Department for their extensive support on this. Public validation follows as well as ensuring community leaders understand the law before finalizing and presenting the legislation to Parliament. Lesson learned from this process is that the review of the provisions needs to be done more than one time and by different agencies or partners. So this will ensure that you identify and or partners can identify needs for changes to best practices to ensure the law is clear. So having key stakeholders is in the process is also crucial to ensure that their needs is reflected and or concerns are addressed during the drafting. Public consultation is crucial and a must-have to ensure you all have the full support of the grassroots communities on this. Next slide. Next slide, please. Okay. Well, so in general, this is an overview of the process we must go through to get established our cybercrime law. So from policy to adopting a model law to our law will be based on identifying and reaching out to international partners to draw from their expertise and advice. Next, it will always better to do a legislation gap analysis, so you know what exists and what needs to be amended or repealed as the need arises. In drafting, it will be crucial to have on board key stakeholders, and so you can work with partners iteratively in reviewing provisions in the draft to ensure full alignment to model law and is clear and does not create legal ambiguities then once you have a refined view. Carry out a public consultation for acceptance by the public. Finally, the final bill was tabled in Parliament and was passed, becoming an act for the nation. Next slide, please. So thankfully, last month, the Commonwealth has approved for Kiribati to send a formal request to the Council of Europe to join the Budapest Convention on Cybercrime. Now we are working with the Ministry of Foreign Affairs and Immigration to send this request to the Council of Europe. We have also organized and plan to link the Council experts with judiciary, prosecutors, and law enforcement for institutional capacity. And this is our next challenge currently, the capacity to investigate and prosecute cyber criminals. But we're glad to have links to the Council and other regional partners to assist in our next step. So we progress with this. We are also actively pushing our foreign affairs colleagues as we try to expedite our accession process, knowing this could take a long time. But we are still ambitious and looking forward to the day when we become parties to the convention as well. In conclusion, it's never too late to start setting up legislations that will guard our fellow islanders. So we hope our journey and lessons we learn plus the process can assist you in your journey to establish your cybercrime laws, combat cybercrime, and ensure we have a peaceful cyberspace in the Pacific. Thank you.
Thank you very much, Terianna. That was a fascinating account on its recent achievement, that is passing its cybercrime legislation. And I think that leads in perfectly to our next presentation from Mrs. Tupou Vainikolo from Tonga. Thank you very much, Tupou.
Thank you, Attorney General, and thank you, Terianna, for that presentation as well. So I'll be presenting on the roadmap to implementing the Budapest Convention from Tonga's experience. Next slide, please. The presentation will cover the following topics. Firstly, how Tonga acceded to the convention. Secondly, the implementation of the convention, and there are four categories that I will be talking about. Firstly, the legislative framework in Tonga, the current legislative framework. Secondly, proposed legislative reform. And third and fourth, the challenges and advantages of acceding to the Budapest Convention. I'll go into an overview of capacity building programs. I think that's very important for other countries who are looking to accede to the convention, just to know that these are available in terms of assistance. Then I will move on to the priorities for Tonga and the way forward, and then I will conclude. Next slide. So Tonga was invited to attend Octopus conferences and meetings of the TCY, or Cybercrime Convention Committee. And from this, government acknowledged the importance of cybercrime and electronic evidence issues in Tonga. Tonga then expressed an interest to be a party of the convention in 2014. And it then became a priority country under the GLACI project. So this was even before Tonga acceded to the convention. We received assistance in acceding in the process. Next slide. Tonga was invited by the Council of Europe to accede, and it deposited its instrument of accession in July 2017. It became a full party after 3 months, becoming the 55th party to the treaty. And today, Tonga is still a priority country under the GLACI Plus project. So the GLACI Plus project is just a continuation of the GLACI project, which assists countries in implementing the Budapest Convention. Next slide. In acceding to the convention, Tonga had to meet the minimum requirements, namely legislative compliance, and also indicate the competent authorities for extradition, which is the Attorney General's Office, for mutual legal assistance, which is also the Attorney General's Office. And we also had to indicate who would be the 24/7 contact point or point of contact under the convention. And currently, that is the Attorney General's Office and the Tonga Police. Next slide. So in order to accede, Tonga had to demonstrate that he had the legislative framework in place. And the list of laws that I've put in this slide are mainly, basically, majority of the laws that form Tonga's cybercrime legislative framework, that formed its framework at the time that we acceded, except for the fourth law down that's listed there, the Electronic Communications Abuse Offences Act 2020. That act came into effect after we acceded to the convention, and I will talk about that law later. But just for your information, this is currently the cybercrime legislative framework in Tonga. Next slide. So in terms of acceding to the convention, Tonga displayed Tonga's national legislation already somewhat substantially complied with the Budapest Convention. And the next few slides, including this one, will display how Tonga certain provisions or certain laws in Tonga did comply with the Budapest Convention at the time of accession. So in terms of Article 1 of the Convention, the definitions, all of these key definitions in Article 1 are contained in Section 2 of the Computer Crimes Act. In terms of Article 2 to 6, which deal with offenses against the confidentiality, integrity, and availability of computer data and systems, this our Computer Crimes Act, Section 4 to 8 complied with these articles. In terms of Articles 7 and 8, computer-related fraud, our Criminal Offences Act, the sections that you see in the slide there, 53, 158, and so on, these are fraud-related offences. This combined with the definition of electronic record in our Evidence Act and the evidence admissibility of the admissibility of electronic evidence provisions in our Evidence Act. These complied with Articles 7 and 8. So you see here, just from this slide that Tonga's compliance, legislative compliance with the Budapest Convention is not just contained in one legislation. There's various legislations that deal with various parts of the convention. Next slide, please. In terms of Article 9, offenses related to child pornography, there were already provisions in the Criminal Offences Act, namely Section 115A. We also had a Pornography Control Act in place. And under the Communications Act, there's also obligations there for service providers to regulate online child abuse material. Online child pornography. The Evidence Act was also relevant in terms of complying with Article 9. You'll see throughout this slide that the Evidence Act is key because it deals with the admissibility of electronic evidence, which applies to all of the criminal offenses, which applies to cybercrime. In terms of Article 10, offenses related to infringements of copyright and related rights, Tonga had a Copyright Act, and that, together with the provisions in the Evidence Act, complied with Article 10. Article 11, attempt and aiding or abetting, Section 8 of the Criminal Offences Act was relevant to that article, as well as the Evidence Act. The relevant sections already provided there, Section 2 and Sections 54A to 54I. In terms of Article 12, corporate liability, the Interpretation Act defines the meaning of a person to include incorporate and unincorporate persons. So that extended to certain criminal provisions or cybercrime provisions in other laws. Also, the Communications Act imposed corporate liability on service providers in terms of what I mentioned previously, having to regulate or report, especially if they saw any pornographic material being distributed on their service. So Article 13, in terms of sanctions and measures, the provisions that I've already referred to already had criminal sanctions for offenses that are reflective in Articles 2 and 10 of the Convention. However, just to note, later on I will refer to this, we did undergo a legislative review, and in that there were proposed amendments to increase the sanctions of certain cybercrime or criminal offenses. Next slide, please. In terms of Article 14 to 21 of procedural law, Tonga already complied with certain aspects of this in its Computer Crimes Act, in the Magistrates Court Act, in its Tonga Police Act, and again, Evidence Act. In terms of Article 22 of jurisdiction, this was provisions for this were already provided in Tonga's Computer Crimes Act. Mutual assistance under Article 25 and 34. Again, Tonga already had a Mutual Assistance in Criminal Matters Act, an Extradition Act, and Foreign Evidence Act, which provided for this. And Article 35, dealing with the 24/7 network. I did mention this before, that currently the Attorney General's Office and Tonga Police are the points of contact in Tonga. Yes, next slide, please. Yes, so the tables that I had just we had gone through, that's the current the legislative framework that Tonga had when it acceded to the convention back in 2017. Now, since then, we have had a legislative review of the legislative framework in Tonga. And out of that legislative review, well, before I go into that legislative review, we did receive assistance from the Department of Foreign Affairs of Australia under a consultant. They had a consultant, Catherine Smith, who assisted us with this work. We were also assisted by the Attorney General's Office of Australia's drafting team, and also the Council of Europe in carrying out this legislative review. And out of that review came several proposed legislations. We proposed to repeal and replace the Computer Crimes Act with a new Computer Crimes Bill. And there were other consequential amendments to various laws. This included our Criminal Offences Act, Evidence Act, Copyright Act, Interpretation Act, and so on. Now, the legislative review focused on the following areas: on increasing the criminal sanctions, on widening procedural powers, and on strengthening the mutual legal assistance powers and functions. To date, these bills are still in bill form because they lack political will. Since accession in 2017, there were several political events that occurred in Tonga. If anyone recalls, there was our first ever vote of no confidence in the government of the day, and then a year or two after that, we had our Prime Minister of the day who passed away. So we had to elect a new government to take over. So there's just been certain events that have affected political will in getting these bills approved or adopted by the Legislative Assembly. However, political will was gained for the Electronic Communications Offences Abuse Act 2020, which came into effect in August 2021. So this has always been a priority, I'd say, in Tonga, even when we were consulting under the computer crimes bills and consequential amendments, the issue of cyberbullying. And so government of that day always wanted those provisions in the computer crimes bills. But in 2020, the government of that day only wanted the cyberbullying provisions in a separate, less complex bill. So that gained political will. We again contracted Catherine Smith, consultant funded by DFAT, and with her assistance, a certain provision out of our computer crimes bill was pulled from that and placed in the Electronic Communications Offence Abuse Act. This was done with the view that if government gains political will, only minor amendments to the computer crimes bill and consequential amendments had to be made at a future stage to be passed. So next slide, please. In terms of challenges, since we acceded to the convention, so the challenge would be legislative review, just in terms of the resources and human resources and resources that it takes to carry this out. But thankfully, there's so much help out there from the Attorney General's office, from DFAT, funding, consultants, or even Council of Europe, who assist in this legislative review. Also, another challenge would be maintaining political will at the highest level. I've already explained that. Third point there is lacking local technical capability to meet international standards. So this is one thing that service providers indicated as well when we carried out consultations, that their capability, they're not capable of storing large amounts of data if ever we requested, or law enforcement requested interception, real-time interception. So that's a challenge, I guess. Next slide, please. Another challenge is mandating ISPs to improve technical capability to meet convention requirements. Sorry, I referred to that in the previous slide. Additional to technical capability would be just experts in Tonga, having experts in the ICT, or building the capacity of our CERT, or even the police investigators. And another challenge would be reliance on Australia and New Zealand for forensic capability, which is quite costly and time consuming. Next slide, please. So some advantages. Of course, legislative review would be a disadvantage if you have lack of resources, but it's definitely an advantage. So you can know where you're at, so you can see what areas need to be reviewed or improved or repealed and amended. Meeting international standards by acceding to the convention, we did indicate to the international fora that we meet these standards, and so that's in a way a confidence building measure to other countries. We are also contribute to the convention discussions as a TCY member. Increased international networking, because cybercrime is a transnational cross-border issue, this is really important. Next slide, please. Again, other advantages, improved international cooperation, again, establishing the 24/7 contact points of contact, establishing Tonga CERT to deal with incident handling, training opportunities for judges, prosecutors, law enforcement, and IT personnel. Being updated on the latest trends and issues via the Budapest Convention community and information sharing. So I think information sharing is one of the biggest benefits to Tonga as well. For example, this led to the establishment of Tonga CERT. Next slide, please. This is just an overview. It's not an exhaustive list of all the capacity building programs, but it's just to let everyone know this is what Tonga has had the benefit of receiving, and it's also there if anyone needs it if you're working towards a session. So under the Glacier Plus project, again, we've received assistance in terms of harmonizing our legislation, judicial training, law enforcement capacities, international cooperation, information sharing, and assessment of progress. We've also been able to attend and participate in regional and international workshops. The Attorney General's Office, Department of Australia, Council of Europe have provided assistance with legislative review, as I had mentioned before. Again, Council of Europe, 2 times now have Council of Europe together with our Ministry of Justice and CERT. They've co-conducted an in-country judicial training. I think the first was in 2017 and the next one was in 2018. But there's still talks to continue this training. Ongoing online practitioner to practitioner workshops. So this is the International Network of Judicial Trainers. And I've had the benefit of participating in this, even sharing Tonga's experience on some issues. But it's great to tune in to that to those workshops which happen every month, and you can hear what other countries are going through or experiencing, and you share experiences in prosecuting or judging or investigating cybercrime. Prosecutor training hosted by Tonga and funded by the Commonwealth Secretariat and Glacier Plus project. So that was one carried out a few years ago. The PILON annual cybercrime workshops, funding to attend and participate. There's ongoing webinars like the webinar today, including training with Meta on law enforcement, on their law enforcement portal. As I mentioned before, cyberbullying, especially on social media, the Meta platform is a big issue in Tonga, one of the priorities, and webinars of that sort greatly assist with the law enforcement. There's ongoing Interpol training, either here in Tonga or abroad. There's a stakeholder training. There was a stakeholder training under the for the Electronic Communications Abuse Offences Act in June 2021. And the Council of Europe was very kind to assist with providing the online platform. As you see, that stakeholder training took place during a time when COVID-19 happened and our borders were still closed. And then just a few trainings from years ago. There's the Global Prosecutor E-Crime Network, and there's also the Pacific Transnational Crime Network. So again, this is not an exhaustive list, but these are certain capacity building programs that Tonga has had the benefit of participating in. Next slide, please. In terms of priorities for Tonga going forward, definitely full legislative compliance with the Budapest Convention, and secondly, ongoing capacity building of stakeholders, namely to address current issues of misinformation and cyberbullying. Thank you. And just in terms of the way forward as well, again, Tonga looks to having continuous capacity building and participating in those, maintaining international standards through compliance or full compliance with the convention, and improving international cooperation. By improving international cooperation, I guess that would mean fostering new and strengthening existing relationships with key stakeholders, either in country, regionally, or internationally. And also, lastly, they're attaining technical capability and maintaining it. So that concludes my presentation. If you have any questions, I did see there was a question in bar. So TCY means Cybercrime Convention Committee, for your information. Thank you.
Thank you very much, Tupou. And although it has now been a few years since Tonga ratified the Budapest Convention, we in Tonga are pleased to share our story on the pathway forward from ratifications. Thank you. At this point, we would like to check out our live scribe, Jessamy, to see how her graphic illustrations are going. Thank you, Jessamy. We always appreciate your excellent illustrations provided in portraying the discussions that have been put forward by the presenters. Ladies and gentlemen, I'm very pleased to now turn to Ms. Catalina Stroe, who will now present on the Budapest Convention and the assistance that the Council of Europe can provide in relation to ratification and domestic implementation of the obligations in the Convention. Thank you, Catalina.
Thank you very much, Attorney General Linda, for giving me the floor. Before starting, maybe just a brief introduction from my side. I am a program manager with the Cybercrime Program Office of the Council of Europe, sitting in Bucharest, in Romania, from where I'm speaking now. Previously, I was working both in public and private sector. I have significant experience in terms of regulatory measures to be put in place when acceding to various conventions, or also for the Romanian experience when we acceded to the European Union back in 2007, and also in the private sector working for as a white-collar crime defense lawyer, and also part of forensic investigations. I was leading forensic investigations, including digital forensic investigations. So I will remain at your disposal in case you would like to explore more also from my previous experience. I call my presentation a call for harmonized legal frameworks on cybercrime and electronic evidence, and I am very happy to see that my previous speakers, to whom I am very grateful for their presentation, to Terianna and to Tupou, that they already laid very well the ground for my exposition now, because they already mentioned key elements, and I remember one very important note that Terianna made regarding that it is never too late to start considering amending the legislation, and I am happy to continue in the same path, let's say. I would just give you a brief introduction on why we should address cybercrime and why we should address electronic evidence. Cybercrime, as already mentioned that by previous speakers, is cross-cutting issue. It is a cross-region issue. It is a threat to fundamental rights, and it affects the right to private life of hundreds of millions of individuals. So personal data are stolen. We also recent attacks, and one just very recent example is the, for example, the Costa Rica experience, where they had massive ransomware attacks on their systems to governments' sites. There were threats to the private sector, also private companies, that can be attacks against the dignity and integrity of individuals, in particular sexual exploitation and abuse of children. Cybercrime is a threat to freedom of expression when attacks are carried out against media, civil society organizations, with particular implications on, let's say, cybercrime, targeted gender issues. It threatens public security and services such as government, parliaments, and other public institutions and critical infrastructures. It is a threat to democratic stability when ICT is used for xenophobia and racism or radicalization and serve of terrorism, and also undermines the trust in democratic institutions. Just to mention one aspect of that, by interfering with the electoral process. And this is just about the cybercrime part, not to mention and not forget the electronic evidence. Just 4 years ago, European Commission estimated that 85% of all criminal investigations require e-evidence, and of that percentage, 2/3, that means 65%, are said to involve a cross-border request to a service provider. 55%, so more than half of investigations, of all investigations, include a request to cross-border access to electronic evidence. And that was 4 years ago. So it is really important to be able to address cybercrime in a harmonized manner. It is important for all of us to be able to have harmonized legal frameworks, to be able to respond as an international community, and to be able to support one another in this cross-border access to electronic evidence. What is the approach of the Council of Europe to be able to support states worldwide in fighting cybercrime? And on the screen now you see what we call the triangle of protecting you and your rights in the cyberspace. In the upper part, you see the common standards, Budapest Convention on cybercrime and related standards. I will present briefly in a minute some key elements of the Budapest Convention. On this slide, I would like just to briefly mention that it is not just Budapest Convention, it is also the 2 additional protocols that the convention has, the one on racism and xenophobia through ICT means, and the other one just recently adopted and then open for signature this year in May in Strasbourg on enhanced international cooperation on electronic evidence, but also TCY guidelines and TCY guidance notes. That is the second pillar. The already Tupou mentioned the Cybercrime Convention Committee, TCY. This is, let's say, in common conventions language, the conference of the parties. So all parties to the convention are part of this committee, but also the states which are formally invited to accede, and we will see later on what that means and how you would be able to be invited to accede and to further become a party to the convention, are also observers. These countries that are invited to accede are also observers to the TCY committee. Its role is to assess the level of compliance with the Budapest Convention. It is to offer further guidance to the parties and to the observers in terms of how to interpret Budapest Convention, how to adjust the legislation, how to respond to particular emerging threats, let's say. And last but not least, the third pillar is the capacity building program office, CPROC, in short, which offers technical cooperation programs. I was speaking about the cybercrime program office. Now we have currently 5 ongoing projects, out of which 2 are global. The already mentioned GLACY Plus project that I am co-managing with another program manager here in Bucharest, and Octopus project. Basically, our overall task is to support the countries worldwide to strengthen criminal justice capacities on cybercrime and electronic evidence, and to enable as such the countries to be able to effectively engage in international cooperation. We currently are 37 staff, and the office is operational from April 2014. Just to give you a number to have a sort of an image, an idea of our activities, until now we have organized and implemented more than 1,000 activities, capacity building activities. And in the last year, I think we had around 400 capacity building activities at the level of the entire cybercrime program office in Bucharest. Turning now back to the Budapest Convention, it was negotiated by the Council of Europe, 47 member states, Canada, Japan, South Africa, and US. So you can see that although it is a Council of Europe convention, it was not negotiated only by the members of the council. It was open for signature in November 21st in Budapest. This is also the name, the Budapest Convention, and has, as I mentioned, 2 additional protocols. Currently, there are 66 state parties and another 15 signatories or formally invited to accede. And as of today, it is the only international treaty on cybercrime and electronic evidence. I mentioned also the Cybercrime Convention Committee that supports the implementation of the Budapest Convention, of the convention itself. All state parties have members in the committee, also 13 observer states and 12 organizations. Its main functions is to assess the implementation of the convention, to issue guidance notes, and draft future legal instruments, like, for example, the newly second additional protocol. Tupou already mentioned that Tonga, as party to the convention, also participated in the plenaries of the TCY. It has an effective follow-up mechanism through which it assesses the implementation of the convention. And I will share after the presentation some links in the chat for you to see where you could find the TCY reports, but also various guidance notes and assessments that TCY made up to date. I am now turning quickly to the reach of the Budapest Convention. Already I mentioned there are 66 parties, 2 signatories, and 13 invited to accede. But the outreach of the Budapest Convention is much broader than that. Our organization is publishing periodically report on the global state of cybercrime legislation, and the last updated version was done in January this year. I will also share in the link in the chat the link to this report, but just to give you some idea of the numbers, 128 states, that means 66% of the UN member states, seem to have had substantive criminal provisions in place to criminalize offenses against and by means of computers, largely in place with the Budapest Convention, and that was by as of January 2022, as I mentioned. Of course, there is a very good progress since 2013. And in this report that I was mentioning, you will be able to see various statistics on the progress made, with a significant pace of reform increased since 2018. So 4 years ago. Zooming now closely on the Pacific region, by 2018, 46% of the UN member states of Pacific had largely in place legislation by January 2022. There was an increase of more than 20% in this in the legislative reforms on substantive provisions, signifying that more than half have now legislation largely in place, adopted specific domestic provisions to correspond to most of the substantive criminal law provisions of the Budapest Convention. If we have a closer look to the procedural powers provided in the Budapest Convention in terms of the UN member states in Pacific, the percentage doubled since 2018. That means more and more countries in the region are looking at and take significantly steps to adjust their legal frameworks on procedural powers on electronic evidence to be in line with Budapest Convention. Now, just briefly on the Budapest Convention itself, of course, I will not be able to have enough time to give you let's say, an exhaustive overlook over the provisions of the Budapest Convention. But just to mention, it has 3 pillars: the substantive criminal law provisions, and these are the this is the part where the the forbidden conducts are provided, and then the procedural powers, and the 3rd pillar, the international cooperation. You will see the next slide, which I'm going to pass quickly through. They relate to various particular aspects for each of the offenses. I'm not going to go through that now because I just wanted for you to have these slides for a further reflection on the convention. Maybe just to mention that the list of offenses included in the convention represents a minimum consensus on what should be criminalized, not excluding extensions in domestic law. And Tupou already mentioned that Tonga decided to criminalize cyberbullying. Cyberbullying itself, as provided in criminal justice, in criminal system in Tonga, is not included in the Budapest Convention. But of course, the Budapest Convention is a minimum standard. It can, one country can decide to criminalize more conducts depending on the national context, depending on the legal system, depending on their experiences and the needs and the challenges, the threats that one country deals with at a particular moment. What it is wonderful about the convention is that although the substantive law provisions relate to offenses using information technology, so ICT, the convention uses technology neutral language, so that the substantive criminal law offenses may be applied to both current and future technologies involved. And the mere fact that Budapest Convention is a live instrument after 20 years last year, when we anniversaried 20 years of Budapest Convention, the fact that it is still the only international reference treaty on cybercrime, it is the perfect proof to clarify that the convention, using the technologically neutral language, was able to remain relevant throughout these years. I would mention just maybe two more points of the convention on the substantive offenses. One being the fact that a specificity of the offenses included in the express requirement of the convention is that the conduct involved is done without right. It reflects the insight that the conduct described is not always punishable per se, but may be legal or justified not only in cases where, for example, classical legal defenses are applicable, like consent, like necessity, self-defense, but where also other principles or interests leads to the exclusion of criminal liability. The expression of without right derives from its meaning from the context in which it is used, and without restricting how parties may implement the concept in their domestic law. It may refer to conduct undertaken without authority, for example, whatever legislative, executive, contractual, or consensual, or conduct that is otherwise not covered by principles under the domestic law. Why I mention that? Because the convention therefore leaves unaffected conduct undertaken pursuant to lawful government authority, for example, where a party a government acts to maintain public order or to protect national security or investigate criminal offenses. The second aspect that I wanted to mention is that all offenses contained in the convention must be committed intentionally for criminal liability to apply. In certain cases, an additional specific intentional element form is part of the offense, like, for example, the Article 8 on computer-related fraud, where the intent it is qualified to procure an economic benefit as a part of the constitutive element of the offense. Again, why I wanted to mention this, because the exact meaning of what intentionally means should be left out to the national authorities to interpret. There are also some certain articles in this section, in this pillar of the convention, allowing the addition of qualifying circumstances where implementing the convention in the domestic law. For instances, there is even the possibility for reservation to be made according to Articles 40 and 42 of the treaty. And this approach provides flexibility to the national authorities in determining their criminal policy in the area. That was the exact point that I wanted to make, and this is why I chose these very narrow or very strict concepts to explain, or only these 3 concepts to explain in terms of the first pillar, because I wanted to show you that the convention, it is pretty flexible. It gives the possibility to one state that considers to reform the national legal framework in line with the convention, gives the flexibility to make sure that the domestic national legal framework is fully reflected, but also in the same time giving the possibility to the country to be in line with the convention. Now moving to the procedural powers, the second pillar. just to mention, I will just relate to the scope and the conditions and safeguards. And before doing that, I just wanted to note that all articles in this section refer to competent authorities and to the powers they shall be granted for the purpose of specific criminal investigations or proceedings. And this is another way that flexibility, showing how flexibility it is provided in the convention, because in certain countries, for example, competent authorities may mean only judges, because only judges have the power to order or authorize the collection or production of evidence, while in other countries, prosecutors or other law enforcement officers are entrusted with the same or similar powers. So therefore, competent authorities can be interpreted one way or another in domestic legislation, but in the same time maintaining the alignment with the convention, because all that the convention mentions is that competent authorities should have these powers to address the collection and use of electronic evidence. In terms of the scope of the procedural powers, each party shall apply these powers and procedures to criminal offenses established throughout the articles 2 to 11. That means the substantive part, the cybercrime offenses that are provided in the first pillar of the convention, other criminal offenses committed by means of computer system, and this is really, really important, the collection of evidence in electronic form of criminal offense. That means any criminal offense, with some very small exceptions that you may find in Article 21st with respect to interception. This means that the procedural powers can be applied to a murder case where the evidence is stored in an email account, or in a tax evasion or money laundering case where the electronic evidence is registered in the accounting system of the perpetrator. These are just examples of how important the procedural powers are. These procedural powers, they don't come by themselves. They are applicable or usable under conditions and safeguards, and the parties to the convention and also states that would like to be in line, bring their legislation in line with the convention should consider. That means they would need to consider inter alia judicial or other independent supervision, grounds justifying application and limitation of the scope and duration of such power and procedure. You will not find in the convention which type of conditions and safeguards you should apply to each of the procedural powers. This is left totally at the level of the party. Why? Because we have different legal systems, we might have different legal principles, or we might have the same legal principles, but we apply them differently at domestic level. So again, the flexibility of the convention to make sure that the procedural powers have conditions and safeguards when to be applied, but in the same time, what type of conditions and safeguards are left at the level of the country. Just giving some examples of what they should be there. You see here a triangle that I pretty much like, that depicts the various procedural powers that are provided in the Budapest Convention, and the triangle is construed from top to bottom based on the intrusiveness of the procedural powers. So you can use this triangle to somehow consider when you are reforming the procedural powers and to see what kind of conditions and safeguards, starting from expedited preservation, which is the less intrusive procedural power, to interception of content data, so real time interception of content data, which is the most intrusive and should have the strongest safeguards in place, for example, judicial or other independent supervision. Again, all procedural powers are provided from Article 16 to 21 in the Convention. I will not go now through each of the provisions. I can share later in the chat the link to the Convention if you would like to see the actual provisions. And now on the last pillar of the Convention, I would limit my speech, my intervention, only to mention that the international cooperation tools and procedures in the third part of the Convention match the procedural powers at domestic level in the second part of the Convention. And here I made sort of a sketch on how they interlink one to another. Basically, if you have a case that involves electronic evidence, again, in any criminal case with some exceptions that you may find in the Convention, you should be able, as a party to the Convention, to engage in international cooperation based on the provisions of the Budapest Convention, to request, for example, expedited preservation of stored computer data from another party based on Article 29, because the other party has or should have in the legislation a particular provision which transposes Article 16 of the Convention on Procedural Powers, mandating or allowing the national competent authority to request expedited preservation of stored computer data from custodians or service providers or whomever other person or entity that is the custodian of the stored computer data. I would not go more in details on the Convention itself because we don't have the time. Shortly on how you could join the Budapest Convention, I already mentioned, but it should be stressed again, the treaty is open for accession to any state. The only condition, let's say, is that the country should have legislation in place or at advanced stage of alignment with the Convention. Our colleagues from Kiribati and also Tonga, they already presented their path, their journey to accession in various stages. We work closely with countries which are interested to accede to the Budapest Convention, but not only. One country may decide at one point that would like to reform the legal framework, but not consider the accession in that particular moment. This is also a possibility. We would be able to work through our Cybercrime program office in Bucharest to adjust the legislation, and then you would, let's say, further consider in near or distant future to consider also the accession. So if a country has the legislation in place and it is interested to accede to the Convention, as Terianna already mentioned, there is a need from a letter from the government to the Council of Europe expressing the interest in accession. This comes through the Ministry of Foreign Affairs or another diplomatic representative who is able to, who is mandated to engage the state in international relations. And then the process moves in the Council of Europe, where consultations with the member states of the Council of Europe and also to all parties to the Budapest Convention are made with a view to take a decision to invite the country to accede, and then let's say a report is done, a summary of the work with that particular country, or what is the status of the legislation is in the country, is presented to the Council of the Committee of Ministers, and then the Committee of Ministers of the Council of Europe takes the decision to invite the country to accede, the formal invitation. This is through sending, let's say, closing the gap and sending the circle, and sending the invitation to the country through the same path to the Ministry of Foreign Affairs to invite the country to formally accede. Between that moment and when a country can become a full party, one state has the possibility, has a time span of 5 years to finalize the domestic procedure of fully acceding, because when a country receives the invitation, it is only invited to accede. It is up to the country that within 5 years finalizes the process and does whatever it is needed according to the national legal framework to accede. That it can mean in practice usually ratifying act by the national parliament. In some cases, it means only a decision of the president, for example. This is totally in line with only the national legal framework. So the country has 5 years. Of course, during this time span, in case the country still has reforms to address, it can do so to make sure that when depositing the instrument of accession, will be able to engage in international cooperation after these 3 months that Tupou already mentioned will be over, because after the instrument of accession is deposited, there are 3 months. After 3 months of depositing the instrument, the country becomes full party. So the convention comes into effect for that particular country. 2 or 3 very important notes in this process. After one country is formally invited to accede, it becomes an observer to the convention. That means it can participate in the TCY committee as an observer. It will be invited to all plenaries, and also has and will be supported through our cybercrime program office, depending on the needs, with further more structured capacity building activities to make sure that within this time span from when it is invited to accede until full accession, we also build together the capacities to implement the national legal framework, which is usually recently adopted, or to fully understand and prepare law enforcement and criminal justice authorities in that particular country to engage in international cooperation. Another important note, it refers to the deposit of the instrument of accession. In the same time with depositing the instrument of accession, it is important to file also the declarations that I think Tupou mentioned, the declarations on who is the 24/7 point of contact, the declaration on who is the central authority for extradition, declaration on who is the authority for mutual legal assistance procedures. Also, at this time of depositing the instrument of accession, the country has to make the reservations if case may be. Throughout the convention, you will find, and I already mentioned with respect to the substantive part, the first pillar of the Budapest Convention, some of the reservations that can be made. Some of the provisions leave the possibility to the country to make reservations. So you would need to make sure that you have a clear picture of what you would like to abstain from. So you make the reservation in the same time with depositing the instrument of accession. There is here a link on the benefits and impact of the Budapest Convention. It is a very interesting report, so if you would have time to read it, that would be excellent. Briefly, I mentioned before that now we have also a second additional protocol to the Budapest Convention, which was open for signatures in May this year. At this point, has 24 signatures. Of course, to become a party to the second additional protocol, so to be able to sign the second additional protocol, you would need to be party to the mother convention. I know that it may not be, let's say, too relevant at this point, considering that maybe in the region countries are still considering reforming the legislation in line with the convention and not considering the second additional protocol. Just to mention 2 points here. It was drafted and now open for signature after following more than 4 years of negotiating with the existing parties to the convention, and it was put into let's say into the opera, into effect, because it was a much needed additional tool to be able to effectively or more effectively respond to the needs for cross-border access to electronic evidence and direct cooperation with service providers in other jurisdictions. Maybe because Tupou gave me an idea while she was presenting, maybe just to give you a flavor of why this protocol might be interesting for countries in the region. She mentioned that one of the challenges that Tonga is facing is that the forensic capability is lacking in forensic capability, knowledge and expertise is lacking in Tonga. So they will have to bring from example from Australia. So that means time consuming, but also additional costs. The protocol can serve, or the provisions in the protocol can serve. There is a particular article on video conferencing. So, for example, if Tonga needs to have an expert witness in court on forensic, on digital forensic, to testify on digital forensic, it may use, if becoming party to the second additional protocol, and when this will enter into effect, can use the provisions on video conferencing to video hearing the person, the expert witness on forensic, on digital forensic, without bearing the costs and in a timely manner. And that would be just all that I would like to present on the protocol. We have various information available on our website on how we end up having the protocol, what is the process, and what are the particular provisions that, and I will share quickly after the presentation a link in the chat. Last but not least, if you would like to learn more about our community, Tupou already mentioned that we have a strong community, a cybercrime network of professionals. We have country wikis. This is a short summary of many countries and idea of the legislation in that particular countries. We have the training materials, the standard training materials also available on our website, and you can subscribe also to our newsletters. Very important to mention, we have a new help course. This stands for Human Rights Education for Legal Professionals on cybercrime. And here you have a QR code that you can use. It is totally online. It's an e-learning course that all legal professionals can access. It's free of charge and you can do it in your own pace. I really hope that I managed to convince you that we need a harmonized legal framework to work in our benefit and to enable us to engage in international cooperation. I thank you very much for your attention, and I remain at your disposal in case you would have further questions. Thank you very much, Linda. Back to you.
Thank you very much, Catalina, and your presentation clearly provided and outlined the requirements for the convention and the types of assistance that the Council of Europe can offer very clearly to us, which I think a lot of people have truly appreciated. That brings us now to question and answers time.
I think one of the questions that was submitted by a member of the audience is, are there any lessons or key things to remember for those who work in small island resource-constrained settings?
Thank you for that question. As you've seen from the presentation, there's a lot of help out there, whether it's in terms of moving towards acceding to the convention, drafting your legislation, capacity building, technical capability. It's available, and so for the small island countries that are resource constrained, like Tonga and a lot of the Pacific Island countries, just ask for help, reach out and send Catalina an email or AGD and say, this is what, you know, your issue is, you need help with this, and they could possibly assist in that. And even Tonga, I guess, would be willing to help steer you in the right direction. So yeah, that's my 2 cents. Thank you.
Thank you very much, and I fully agree with Tupou, although I cannot say that from personal experience, my own personal experience, I have, let's say, first-hand experience on how small islands can work, because I'm coming from a country, let's say, a bigger country than that the islands. But in the past 2 years, I worked a lot with some of the islands in the Pacific, and indeed, the biggest challenge is the lack of human resources. And what we are trying to do, and Tupou already mentioned, is that we try to cover as much as possible from our side the lack of resources when the country deals with the legislative reform. Let's say we are available and on call whenever needed to give appropriate guidance, to give appropriate trainings also to the legal drafters to make sure that the standards are fully understood. And one important note here is that we make sure that every single time that we bring experts on board, they are fully aware of the national context, or if not, we are able to include in the group that we are working with at national level various stakeholders to make sure that all capabilities are covered and all angles. So besides legal drafters, we are discussing with prosecutors, we are discussing with judiciary, we are discussing with law enforcement to make sure that all angles are included. And that would be my key takeaway with respect to that. Make sure that because you are facing limited resources, make sure that all angles are covered in terms of what professionals you include in the legislative assessment.
Thank you very much,
you very much.
Catalina. Yes, thank you. Any other questions?
Chair, Nick has just posted another question from the audience in the chat, which was submitted before the webinar. The question is, would anyone like to offer a brief view or share their thoughts about the relative strength of cyber laws in the Pacific?
In terms of the cyber laws in the Pacific, I'm not really sure about the Pacific, the entire Pacific, but I can speak to Tonga. The relative strength of laws in Tonga. I think we have a good laws in place. As I've demonstrated explained in our presentation, we have a line of legislation already compliant or that aligns with the Budapest Convention. There's just a few tweaks that we need to amend or to improve on, which is why we did the review a couple of years back and had our proposed legislation. I think in terms of jurisdiction, there's a jurisdiction issue of crimes that use electronic means to commit those crimes. For example, I'm talking about traditional crimes of theft, where you would, in the past, go to an actual building and steal a physical object. Now you can just steal money or the identity of a person behind the screen. So in terms of jurisdiction, those kind of traditional offenses which are now committed via electronic means. In Tonga, the jurisdiction aspect needs to be brought in to include culprits who commit those offenses overseas. At present, it only covers Tonga. Our Computer Crimes Act, however, that deals with purely computer-related offenses. The jurisdiction, there's a jurisdiction provision there that allows, that extends to criminal offenses, purely computer offenses that are committed overseas. So that's just one aspect that I've covered, but it's a broad question, and I've just narrowed it down to Tonga. And so yeah, I think we're over the 50% mark at least, probably 60 or 70.
I would kindly ask you also to let me comment on what Tupou mentioned. In my presentation, I briefly mentioned the global state of legislation, the report that we publish periodically. Just to mention that I put in the chat the link to that report, because in the report, our colleagues in the audience would be able to see how the pace of reform significantly increased since 2018, also with respect to cybercrime acts in Pacific. I was mentioning some data and some percentages in the presentation, but you will have the full report in the link that I just posted. So I hope that it would shed more light on how we stand in the Pacific Islands in terms of cybercrime legislation. Thank you.
Thank you very much, Catalina.
Can I ask if there were any unexpected implementation issues that capacity building assistance under the convention helped to address?
Thank you, Lauren. Thank you for that question. As I mentioned before in my presentation, I'm not sure whether it's actually an unexpected implementation issue, because every government has the political instability. I mean, it's there. We know that each government is elected for a certain period of time, and then they have their own set of priorities. But in Tonga's example, I would say it was very unexpected because it was our very first vote of no confidence. We've never had one before. And that happened shortly after we acceded to the convention. And then after that, a few years after that, I think a year or two after that, our Prime Minister of the day passed away. And that's the very first time that a Prime Minister has passed away while holding unexpected implementation issue. I think the capacity building programs that the Council of Europe, that capacity building partners offered Tonga, that was ongoing and irrespective of what was happening politically, and that helped build new relationships, forge existing or strengthen existing relationships in terms of investigating crime for police investigators, in terms of prosecuting and judging crimes. So yes, that helped us deal or work with the current legislative framework, regardless of the lack of political will for our line of proposed legal reform. I hope that answered the question, but thank you.
Ladies and gentlemen, that brings us to the end of our questions and answers session and the end of our webinar today. I hope you have all enjoyed it as much as I have. If anybody has any further questions for our presenters, or if you would like further information about the combating corruption of cybercrime in your country, please email the PILON Secretariat. Sasai and Rosie will ensure you get the information you need. Just before you go, I would like to take the opportunity to inform you all that we will be sending out a very short survey after the webinar. We would be really grateful if everyone took the time to complete this webinar, this form, and to provide the feedback. This helps PILON and the working groups to improve our training in the future. AGD will also post the survey link in the chat for anyone who would like to provide feedback straight away. I wish to thank all three presenters for the wonderful presentation today, and wish all of our participants and a happy and safe Friday afternoon and a relaxing weekend. Thank you very much, everyone. Malo.
Thank you.
And
Thank you very
goodbye.
much.
Thank you
Bye-bye.
very much.